We are continuing to follow the sentencing hearing, of course, out of Georgia for Justin Ross Harris, who you see there in orange. The judge now, I guess, making Joey Jackson here with me, making that recommendation. We lost our feet in our ears for just a second, but now we are back up. So let's take a listen into the judge.
The court pronounces the following sentence in the case of the state of Georgia versus Justin Ross Harris, criminal action 14-93124. As to count 1, the court imposes the conviction on count 1. As to count 3, felony murder, disposition by the jury of guilty, it is also vacated by law due to conviction on count 1. As to count 4, cruelty to children in the first degree, the jury having found the defendant guilty, the sentence of the court is 20 years to serve in confinement. This will be consecutive to count 1, malice murder, life to serve in confinement without parole. Count 5, cruelty to children in the second degree, the jury having found the defendant guilty, it will merge into count 4 as a matter of law. As to count 6, criminal attempt to commit a felony, to wit, sexual exploitation of children, with a disposition by the jury of guilty, the court imposes a sentence of 10 years to serve in confinement, consecutive to counts 1 and 4. As to count 7, dissemination of harmful material to minors, with the jury having found the defendant guilty, the court imposes a sentence of 12 months to serve in confinement, consecutive to counts 1, 4, and 6. And as to count 8, dissemination of harmful material to minors, the jury having found the defendant guilty, the court imposes a sentence of 12 months to serve in confinement, consecutive to counts 1, 4, and 6, and 7. Page 3. Mr. Harris, this is to advise you that you have the right to file any action for habeas corpus brought pursuant to Title IX, Chapter 14, Article 2 of the Official Code of Georgia. It must be filed within 1 year from the judgment of conviction on misdemeanors or 4 years from the judgment of conviction on felonies becoming final by the conclusion of direct review or the expiration of the time for seeking such review. That would be the 5th day of December, 2016. You also have a right to appellate review. I know that you've discussed that with counsel because you and I have discussed that previously. So let this serve to remind you that you have 30 days in which to file the first steps toward appellate review. Mr. Kilgore has already advised the court that he either has or will, I would assume will, file a motion for new trial and take the appropriate appellate steps. Is that still your intent, Mr. Kilgore?
Yes, ma'am. We'll take care of it.
I appreciate that. My final observation is this, Mr. Harris. I went back and reviewed and thought about your statement to the police and your statement to your wife when you were taken into custody. And it stood out to me that in both of those, you took the occasion to express your wish that you would be an advocate so that people would never do this again to their children. And I would say, perhaps not in the way that you intended, but you in fact have accomplished that goal. All right. Anything else for the state?
No, Your Honor.
Anything else for the defense? You can take the defendant into custody.
So HLN legal analyst, criminal defense attorney Joey Jackson standing by with me here. The judge, life without parole plus 32 years to serve consecutively. This is exactly what the prosecution had asked for just moments ago. And then she took that time at the end there to say that she went back and she reviewed Justin Ross Harris's statements to the police and to his wife after He'd been taken into custody. That was really powerful.
Well, let's talk about why it's powerful. Because what she said was you wanted to be an advocate for children. In essence, by pronouncing this sentence, he is an advocate. Why? Because this sentence will deter anyone who even considers or thinks about doing something as inhumane as this from doing it at all. And so in terms of the process, you know, the judge, I think, was very clear with how she felt and what she felt this would be. Now, largely symbolic, again, sentence. You can't do life without parole plus another 32 years, but she's sending the clear message. And so now viewers may say, well, you know, why was it such a truncated process? Why such a short process? What about all the impact statements? What I believe is happening is this. Because there'll be an appeal here, the defense is saving whatever they have for that process. And so they believe, the defense, that they have significant appealable issues. And as a result of that, they'll ask an appellate court to grant a new trial. And with regard to any impact from the victim, remember, that's his son, you know, so who could potentially speak? His wife, right? But apparently there were other thoughts in terms of their process and what they're deciding to do that is a defense. I think they'll put all their eggs in the basket of an appeal, and should there be a new trial, he will have an opportunity to, again, advance his theory of an accident. But this jury, at this time in this place, soundly rejected that notion and said, you know what? You did this with malice. You did it with ill will. The prosecution felt that strongly, and apparently, Erica, the judge did too.
So did the judge, and the judge specifically talked about the jurors. Not unusual, but she said, look, they took the time to deliberate fairly and praised them. And when we listened to the verdict together just a couple of weeks ago, she praised them at that point as well, saying you did your job well, you took it very seriously, you did everything we asked you to do, and took a moment to say that again today.
That's right. You know, this is a process, Erica, and on any given day, everybody has a job to do. The prosecution had their job in laying out their theory. The defense had their job in trying to pick apart that theory to raise reasonable doubt with that jury. And of course, today, it was all about the job of that judge. Having heard the evidence, having considered it, and having allowed the jury to do its job, it was time to do hers. And I think she resoundingly agreed with that jury in terms of what they felt. And that was that this was done with malice, ill will, and he will spend the rest of his life in jail. Plus, again, symbolically, 32 years in addition to that, and taking the opportunity to say that you advocated for children, all right, because no one's going to do what you did to that beautiful 22-month-old child.
I want to play a little bit more of what the judge had to say for some folks who may just be joining us. This is part of what the judge had to say just a little bit earlier in the sentencing hearing just moments ago. Take a listen.
This court finds particularly that the defendant, Justin Ross Harris, intentionally and unnecessarily, in a wanton manner, caused and inflicted upon the defendant, the victim, Cooper Harris, unnecessary and wanton, severe physical and mental pain and agony. The evidence in aggravation in this case is replete by the evidence presented during the 6 weeks of evidence presented to a jury. The jury in this case was diligent and conscientious. They were careful in their observation of the witnesses. They were careful in their note-taking. They were careful when they had the view of the car that was involved. It was not a large SUV. They were careful in observing the seating and positioning of the child safety seat involved in this case. They took careful time in their deliberations. They asked to review evidence that was of concern to them, and it was done so in open court. When they came back into the courtroom to render their verdict, and they were polled by the court and asked if in fact that was their verdict in the jury room, and if it was still their verdict, each stood and each unequivocally said yes, it was. There was no hesitancy, there was no reservation, there was no indirectness in their answers at all. They fairly deliberated and discharged their duties and found the defendant guilty of what factually was a horrendous.
So there we heard part of what you and I were talking about earlier, but just hearing the judge say it all again, as she points out why we ended up at this point now where she said
Yeah.
your sentence is life without parole plus 32 years, which, as you point out, of course, is symbolic, but related to these other charges because there were 8 different counts here.
Right.
And so some of those other counts, among them, we have dissemination of harmful material to minors. That 2 separate counts there,
Yeah.
2 separate 12-month sentences. We also have criminal attempt to commit a felony, and then cruelty to children. 1 count in the first degree, 1 count in the second degree.
Yeah, you know, it's interesting, Erica, what she did, just so that the viewers can understand, when she said life without parole, and she talked about the murder charge, and then she talked about how felony murder and the second felony murder, because there were 2 felony murder counts,
Right.
how they would be vacated by law. He's already convicted of murder, so you can't convict him technically on a felony murder when he's been convicted of the murder. It's a technical point,
Right.
but she ultimately dismissed those 2 charges. And then the cruelty to children charge, she dismissed one of them, or indicated it merged into
sort of
the other.
merged into the other,
Exactly,
yes.
because one was intentional cruelty, the other one was cruelty with negligence, carelessness. The jury said he did both, but essentially she found intent. That's what the jury found. And she said, of course, in going over what the jury was doing and deliberating and taking their time, that she was essentially adopting their findings. That the findings that they made to that court, she got absolutely right. They got absolutely right, and she endorsed that in giving him that stiff sentence.
Joey Jackson, appreciate you helping us to break it down. Stay with us. You're watching On the Story. We're going to continue to follow these developments, but we also want to bring you the very latest